Hi, it's Professor Moore again, and this time I'm making a video for both of my classes, Civil Procedure and Complex Litigation. Civil Procedure students, you're just learning the newest version of the Federal Rules of Civil Procedure that became effective on December 1st of 2015. And the students in complex litigation very likely learned the discovery rules under the prior version and have not been exposed to the very significant amendments that took place effective December 1st, 2015. So I thought I'd kill two birds with one stone and make a video for both classes. So some of this is directed more to absolute beginners. That would be you, civil procedure people. But hopefully it'll be a good review for the complex litigation people as well. This slide is just meant to refresh you or tell you for the first time about the different kinds of discovery devices that are used in order to get facts and information from your opponent or from co-parties in lawsuits or even from third parties in lawsuits. And so this slide shows some of the more common devices for discovery, obtaining information. The gentleman with the boxes at the top left-hand corner of the screen represents document requests, where back in the day, a million years ago, when I practiced law, that's what you would get with a document request. Of course, today it's largely electronic. Below that, the request for admissions is represented there, asking your opponent to admit certain facts. The three photographs in the middle are of various famous people being deposed. So depositions are another very useful way to obtain information from your opponent or from a third party. At the top right of the screen, you see someone answering interrogatories, which are written questions to your opponent responded to with written answers under oath. And then there's a picture of someone doing a medical exam. This happens to say defense medical exams, but of course anyone can do a medical exam if they have good cause to do so. It's just usually the defense who does a medical exam on the plaintiff after getting a court order. So the reason that I started with all of those discovery devices is that it's important to understand that this general definition of the scope of discovery applies to all types of discovery devices. So there's not like a different scope for depositions or what have you. So the scope tells you to what extent can I ask for and receive this information from my opponent or possibly from a third party under the rules. How far can I go? What can I get? That's what the scope of discovery is. And so the general scope of discovery is in 26B1. And despite the lengthy and boring looking nature of this rule, there's really only three qualities of the scope of discovery. So unless otherwise limited by court order, the scope of discovery is as follows. Parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. And then after the needs of the case, there are 6 factors that are listed in regard to whether a discovery request is proportional. I won't read those right now because we're going to go through them one at a time on later slides. And then the final sentence of this provision, information within this scope of discovery need not be admissible in evidence to be discoverable. So you can discover something even though there may be an evidentiary rule that would prevent you from getting it into evidence at trial, such as hearsay for testimony, something like that. So non-privileged, relevant, proportional. Those are the three things we're looking for in the scope of discovery. So I'm not going to spend a whole lot of time on not privileged, non-privileged, because I'm hopefully going to do a separate video on that, or else go through it in class. But some of the most common types of privileges that parties can interpose in response to a discovery request are, first of all, the attorney-client privilege. Secondly, the work product protection, lawyer's work product. And third, your Fifth Amendment privilege against self-incrimination. That's a picture of Mark Furman in the O.J. Simpson case, taking the fifth on the stand. Or I don't know if that was actually when he was taking the fifth on the stand, but you know what I mean. Okay, so non-privileged, that's the first thing that your request has to seek, because if it's subject to a privilege, then obviously if it's privileged, it won't be produced. There are other rules with respect to claiming privilege, but I will get those into those in another video. So the second quality of something that is within the scope of discovery is one that I still consider to be the most important, and probably from the cases I've seen, courts consider this to be the most important. And that is that your request seeks something that is relevant to any party's claim or defense. So where do we get the claims or defenses? In the pleadings. Civil procedure, we're just finishing up pleadings. This is where these are the official papers that take that set forth what the party's actual legal claims are and actual defenses are, and that tips you off as to what is relevant in the case. So nothing is relevant in a vacuum. A piece of evidence is only relevant as far as it goes to prove something that is important to your claim or to your defense. So not every court defines the word relevant like this, but many courts do define it by the definition of relevant evidence in the Federal Rules of Evidence, Rule 401, which is that evidence is relevant if A, it has any tendency to make a fact more or less probable than it would be without the evidence, and B, the fact is of consequence in determining the action. So how do you know what's of consequence in determining the action? Well, you need to know the substantive law. So if you have a simple negligence claim, for example, that the defendant would have breached its duty to use reasonable care, and that plaintiff suffered damages. So whatever fact you're seeking in discovery would have to either tend to make that claim or a fact that's relevant to that claim more probable or less probable. It's not too hard to reach the relevance bar. It's a pretty low bar. So here's an example of a piece of evidence that was sought in discovery that was relevant to a party's claim. So this was in a personal injury action where the plaintiff alleged loss of eyesight due to the defendant's negligence. And so the defendant asked for access to the plaintiff's mobile phone, tablet, computer, and fitness monitoring devices because the use of some of the apps on these devices or the use of the device itself was relevant to rebut the plaintiff's claim that she couldn't see. So the court granted the motion to compel, the reasoning being that it doesn't even matter what the content of these apps are. The fact that she might be able to see these apps or see her Fitbit or what have you is itself relevant to the fact of consequence, which is how damaged really is her eyesight. So here's another example of relevance. This would be relevant to a party's defense and also illustrates how you have to think about the substantive law in the case. So this was a hostile work environment case, a discrimination case, and the defendant raised a common defense in such a case, which was that the plaintiff had failed to timely exhaust her administrative remedies. So the plaintiff argued that the time for exhausting her remedies should be told or shouldn't run because she was so traumatized by the sexual assault that she was alleging that she was unable to effectively manage her personal and business affairs. So the defendant said, okay, well, let's see if you paid your bills during the time that you claim that you were so traumatized that you couldn't manage your affairs. And they wanted to see the records of those payments or non-payments during that time. And the court granted the motion to compel that information. And the court said, plaintiff's financial account activity is relevant to plaintiff's ability to effectively manage her personal and business affairs, and it is within the scope of discovery because plaintiff directly placed that ability, her ability to manage her affairs, at issue in relation to the exhaustion of her administrative remedies. So that's a good example of the paramount importance of the information that you're seeking in discovery has to be relevant to any party's claim or defense. Now, the third element in the scope of discovery, we've got non-privileged and we've got relevant. The third element now is proportional to the needs of the case. And I need to stop this and get the text so that my face isn't covering it. Hang on a second. Okay, that's better. So these factors that go into the so-called proportionality of the discovery request were many of them, most of them, were already contained in Rule 26B. They were just located in the next section, 26B2C. So you can see how they look in the old version, pre-December 1st, 2015, and then the new post-December 1st, 2015 version is on the right side of the screen. I'm going to go through these one at a time. I'm not going to read them right now, but you can see just by glancing at them that they are quite similar. The 2015 amendments kind of rearranged them and reordered them. So, quick review, fill in the blank. Under the Federal Rules of Civil Procedure, parties may obtain discovery of any blank matter that is relevant to any party's claim or defense and proportional to the needs of the case. A, admissible, B, discoverable, C, documentary, D, non-privileged. Okay, that was super easy. The answer was D. Just making sure you're still awake. All right, so let's talk more about the proportionality factors, proportional to the needs of the case. Okay, so as I mentioned, most of the current proportionality factors have actually been in the rule since 1983. They were just located in a different place. And the Poor Advisory Committee has been trying since 1983 to get people to pay attention to the proportionality factors. They keep moving it around, changing a few words, adding this redundant thing, that redundant thing. And finally, and every time they had a chance to say something, they would say, people just aren't following the proportionality factors. So they've moved them up to the first subsection of 26B now. So they're right there, and also changed them a little bit. But they did not, they've said repeatedly that they didn't intend to change the scope of discovery in the December 1st, 2015 amendments. They just intended to make the concept of proportionality more prominent. So courts are pretty much taking the advisory committee at their word on that. For example, one court said, the 2015 amendments constitute a re-emphasis on the importance of proportionality in discovery, but not a substantive change in the law. So we're just trying not to forget it now. So here are the 6 factors of proportional to the needs of the case. And the advisory committee, in its notes, has not weighted these factors. It is to be determined whether a given item that's requested in discovery is proportional on a case-by-case basis. And no single factor is designed to outweigh the other factors in determining whether the discovery sought is proportional. So it's one of these factors analysis where we have no balancing, we have no weighting, we just go through them all and see what applies. So there was a case that came out fairly soon after the amendments took effect called Siriano versus Goodman Manufacturing Company. And it's a good example of the application of many of these factors, although it didn't go into every single one of them. But this was a consumer type products liability class action in which the plaintiffs alleged that air conditioner coils that the defendant manufactured were corroding. And the plaintiffs moved to compel production of other complaints that the defendant had received and documents regarding any investigation of such other complaints, as well as numerous electronically stored information search terms. The court applied the factors in 26B1, the proportionality factors, and granted the motion in part. So first of all, is the discovery relevant to any party's claim or defense? The court said, well, of course. The discovery sought by the plaintiffs, which is these other complaints and investigation of the other complaints by the defendant, is directly related to their claims, which include assertions of defects in the design and manufacture of defendants' condenser coils. Second, after determining that the information sought was relevant, the court went on to see whether it was proportional to the needs of the case. So the first factor is the importance of the issues at stake in the action. This is one of those factors that has actually been in Rule 26 since 1983. It's just been moved up to 26B1. And the advisory committee in 2015 affirmed what it said about this factor in 1983 and said some more. So in 1983, the committee said, the significance of substantive issues as measured in philosophic, social, or institutional terms. That would be the importance of the issues at stake in the action. Thus, the rule recognizes that many cases in public policy spheres, such as employment practices, free speech, and other matters, may have importance far beyond the monetary amount involved. So again, in 2015, the committee reaffirmed what it had said 30 years earlier and added, many other substantive areas also may involve litigation that seeks relatively small amounts of money or no money at all, but that seeks to vindicate vitally important personal or public values. So here's an example of discovery that was sought that illustrates the importance of the issues at stake in the action really well. And that was an environmental case in which the plaintiffs had a National Environmental Policy Act claim, and they sought information that the court described as extremely important not only to the plaintiffs but to all citizens who visit and enjoy the Atchafalaya Basin area. And I probably mangled that name. Sorry to anyone from Louisiana. By the way, I just was reading the note there and I just recalled that what the plaintiffs were asking for there in discovery was kind of interesting. They were asking for permission to enter on the land, and that is one of the discovery devices that is allowed by the rules is to enter property if that is, of course, relevant and non-privileged. Well, I don't know why it'd be privileged. Relevant and proportional to the needs of the case. And this certainly was. The second proportionality factor is the amount in controversy in the case. So before the December 1st, 2015 amendments, this proportionality factor was listed first. And so in response to some public comments that were critical of the changes to the scope of discovery, the advisory committee placed the importance of the issues at stake in the action first. And they said, this avoids any implication that the amount in controversy is the most important concern, especially in a case seeking non-monetary remedies such as an injunction. So the example that was given was, you know, in an employment discrimination case where, say, it's a partner in a law firm who is making $200,000 a year, but then her administrative assistant is making $30,000 a year, and they're both claiming discrimination. Is the one that makes $200,000 a year more important? And is she entitled to more discovery? And I think the advisory committee's answer to that would be no. So back to the Siriano case, the court looked at the amount in controversy there and said, because plaintiffs in their complaint present a putative class action that could include a significant number of class members who each purchased costly products from defendants, the amount in controversy in this matter is potentially very large. The third factor that the court should consider is the parties' relative access to relevant information. And this factor was new in 2015. This was not in the rules earlier. And what this goes to is what civil procedure buffs have come to call cases involving information asymmetry. And this is frequently the case where an individual plaintiff sues an institutional defendant, such as a company or the government agency. And many times in such a case, the plaintiff will not have very much information going into the suit. And really, a lot of the documents, a lot of the witnesses are controlled by the institution, the defendant. And so where one party has most of the information, it stands to reason that they are probably going to incur the most expense in replying to discovery. And so the advisory committee recognized this and said the burden of responding to discovery lies heavier on the party who has more information, and properly so. And so this factor is kind of saying, if this is the kind of case where one party just wouldn't be expected to have information at the beginning of a suit, they might be entitled to a little more than normal. So that factor would weigh in usually the plaintiff's favor. The Siriano case considered this factor and addressed it kind of at length. It said it is highly unlikely that plaintiffs could discover similar information from another source or in another manner. Plaintiffs assert several breach of warranty claims. Documents related to warranty complaints filed by other customers who are not parties to this litigation would be easily accessible to defendants, but almost completely inaccessible to plaintiffs. Additionally, it is much more efficient for plaintiffs to seek information related to defendants' dealings with their distributors from defendants themselves, who have access to all of those records, rather than assemble it piecemeal from the distributors. So in other words, it's just way easier for the defendant to access this information than it is for the plaintiffs. And that counts in plaintiffs' favor in requesting this information. The fourth factor in considering the proportionality of the request is the party's resources. And the advisory committee notes clearly indicate that they are referring to the party's financial resources. So the committee said, consideration of the party's resources does not foreclose discovery requests addressed to an impecunious party, nor justify unlimited discovery requests addressed to a wealthy party. The 1983 committee note cautioned that the court must apply the standards in an even-handed manner that will prevent use of discovery to wage a war of attrition or as a device to coerce a party, whether financially weak or affluent. So in everything the advisory committee had to say on this factor, they were talking about financial resources. So in the Siriano case, the court said, considering the party's resources, that the defendant's corporate resources vastly exceed plaintiffs, and to date, defendants have expended relatively little in complying with discovery in this matter. The fifth proportionality factor is the importance of the discovery in resolving the issues. So what does that mean, the issues? By the time you've gotten this far into the sentence, you've forgotten what that refers to. So if you go back and look at the beginning of the sentence, it starts proportional to the needs of the case, considering the importance of the issues at stake in the action. So then when you go down, and we're talking about the fifth factor, the importance of the discovery in resolving the issues, that is referring to the issues at stake in the action. So how important is the discovery in resolving the issues at stake in the action? And I've got a little picture of a smoking gun there to kind of illustrate, something that would be very important in resolving an issue. So the advisory committee said about this, a party claiming that a request is important to resolve the issues should be able to explain the ways in which the underlying information bears on the issues as the party understands them. So in other words, even though you may not know exactly what it is you're asking for or what you're going to get in discovery, you should be expected to explain to the court why you think what you've asked for is important to resolving the issues in the case. So in a way, this factor is really kind of redundant of the overall requirement that a request seek relevant information that, makes the material facts of the claim or defense more or less probable. But the way I think of this, and this is just me, this is not from the advisory committee, is that this is kind of analogous to, for those of you that might have had evidence already, the probative value of evidence as used in the federal rules of evidence. So you've got this low standard of relevance of a piece of evidence, but then so to say something is really relevant or strongly relevant is just not the correct way of phrasing it, because something's either relevant or it isn't. Probative value is what gives weight to your characterization of relevance. And going into the probative value are really two elements: the strength of the evidence in proving whatever the fact or contention is that it relates to, and how much the party needs this particular piece of evidence to prove this particular fact. Are there 10 other pieces of evidence that could easily prove the same thing, or is this is it to prove a very important fact? So I think that what this factor is trying to encapsulate is the probative value of the requested discovery in resolving the issues in the litigation. Now, at this point, you may be confused because there are two factors which start out the importance of the. And, your mind sort of goes, they're, these are the same thing, but they're not. So the first one was the importance of the issues at stake in the action. And this one that we're talking about now is the importance of the discovery in resolving the issues at stake in the action. So how do those two things differ? A good illustration of the difference is provided by the case of Doe versus Trustees of Boston College, where a student was accused of sexual assault. He claims wrongly, and he claims that the university, in responding to the complaint, violated his contractual rights, due process rights, whatever, Title IX. And so the information that he sought in discovery were prior sexual assault claims brought by non-party students or former students at the college. So he wanted to compare how the university had handled those complaints versus how it handled the complaint against him. And so looking at the first factor, the importance of the issues at stake in the action, that looks to the overall public or private interest that the litigation attempts to vindicate. So here, the court granted the motion in part after considering proportionality, including this one. It said the significance of the substantive issues as seeking to vindicate vitally important personal or public values. So this is a Title IX discrimination claim, considered to be a vitally important public and private value. On the other hand, the factor, the importance of the discovery in resolving the issues, links the specific discovery sought with one or more claims or defenses in the case. So I would call that issue importance. I would call the other one substantive importance. So in the Doe case, the court said the importance of the requested information, these complaints brought by former students of sexual assault, to resolve the causal connection in the gender bias claims under Title IX. The final factor is whether the burden or expense of the proposed discovery outweighs its likely benefit. And, you know, this is a factor that is kind of your overall cleanup. You know, really all they needed to have was this factor because it's a cost benefit consideration. But well, I'm not going to second guess why they wrote it all out, but this factor kind of, you know, summarizes all the other factors. So I would say if a particular consideration in a case doesn't neatly fit into one of the other factors, you know, somehow it'll fit into this. So let me give you an example of a benefit of the proposed discovery. In a Fair Labor Standards Act case, this would be a wage and hour case, a collective action, which is kind of like a class action. The plaintiffs requested discovery that bore directly on the issue of final certification of the collective action. And moreover, the defendant said that it would introduce declarations, in other words, affidavits, from many of the very supervisors from whom plaintiffs sought information. So that was looking at what are the plaintiffs going to get out of this discovery that they're seeking, and it was a lot. Examples of the burden or the expense of the proposed discovery include, most obviously, parties come in and they estimate the cost in either lawyer time or in dollars or both of responding to a discovery request or searching for the discovery that's being asked for. At times, parties put forward a burden that is non-monetary, such as a hospital argued that federal law prohibited it from releasing the documents that the plaintiff sought. And in another example, which I think is cut off your screen, a privacy interest in juvenile records was put forward as a burden in responding to the discovery. When a party says that discovery that is being sought from that party is they will incur much burden or expense in responding to that discovery, the party has to describe the burden. So they cannot merely object that responding is burdensome without identifying the burden specifically. So in one case, the defendants represented that even searching for the emails that the plaintiffs wanted was too burdensome. And the court said, no, that's not going to fly. In the Siriano case, getting back to that, the court considered that final factor, the burden or expense outweighing the benefit, by saying that the defendant's production thus far consists of the electronic disclosure of documents previously collected and reviewed pursuant to discovery in other related cases. So, in other words, the court didn't think that the defendants had really done very much in this particular case in response to discovery. And then the court said, in weighing the 26B1 factors, the court is mindful that defendants' discovery costs could be significant. The Sixth Circuit, where the court was, however, has held that limiting the scope of discovery is appropriate when compliance would prove unduly burdensome, not merely expensive or time-consuming. So again, the party resisting discovery has to be specific in what is this burden, what is this expense. So here's a multiple choice question. It's probably not a very good multiple choice question, but here it is anyway. A woman brought a claim of discrimination in federal court against her former employer for being subjected to a sexually hostile work environment and for retaliatory termination. She has now filed a motion to compel responses to a request for production of documents, which asks defendant to produce copies of personnel files, including supervisor files, disciplinary files, and formal and informal files of 20 specified individuals employed by her former employer. The former employer objected to this request on the grounds that it sought irrelevant materials and was not proportional to the needs of the case. The woman asserted that the individuals listed either played important roles in the employment decisions affecting her or participated in or witnessed the hostile work environment and or retaliation that gave rise to the litigation. Should the court grant her motion to compel? A, probably because the discovery request is relevant to a claim or defense in the lawsuit and the information gathered would be admissible at trial. B, probably because the discovery request is relevant to a claim or defense in the lawsuit and the information gathered would be reasonably calculated to lead to admissible evidence. C, probably not because the information sought is not relevant to a claim or defense in the lawsuit and is not therefore discoverable. D, probably not because requesting the files of 20 people may not be considered proportional to the needs of the case. Again, not claiming this is a great multiple choice question, but it's going to be pedagogically important. So I'm saying the correct answer here is D. And let me go through the wrong choices and tell you why they're wrong. So A was probably because the discovery request is relevant to a claim or defense in the lawsuit and the information gathered would be admissible at trial. The reason that this is not a complete answer is that it doesn't account for the proportionality consideration. Relevance is key and is very important, but the court at this point also needs to look at proportionality. So this information that's being sought is relevant. She's seeking the files of people who, either played a part in the decision terminating her, people who may have looked at or been witnesses to the sexual harassment. And so the information sought is clearly relevant to her claim. Now, the last part of the sentence says, and the information gathered would be admissible at trial. That is not part of the standard. So remember that last sentence of 26B1 says, in order to be discoverable, information does not have to be admissible at trial. So that is not part of the standard at all. So that's why A is wrong. B is wrong for somewhat of the same reason. Says probably because the discovery request is relevant to a claim or defense in the lawsuit and the information gathered would be reasonably calculated to lead to admissible evidence. Now, those of you who have never seen Rule 26B1 before don't understand the significance of those words in that answer. The words reasonably calculated to lead to the discovery of admissible evidence used to be in 26B1 prior to the December 1st, 2015 amendments. They have now been deleted and changed, or the thought of that idea has been kept, but the language has been changed. And so, again, that is not the current standard. And yes, this information is relevant, but it is this answer B is incomplete because it does not consider proportionality. C is probably not because the information sought is not relevant to a claim or defense in the lawsuit and is not therefore discoverable. Again, I think it's pretty obvious that the information sought here is relevant to the plaintiff's claims in the lawsuit. And so C is just wrong. D, probably not because requesting the files of 20 people may not be considered proportional to the needs of the case. And so in this climate, I think that requesting the files, all the files of that many people may well raise a red flag. Because, in fact, how many people could actually be involved in your decision to be fired, and how many people could have witnessed the sexual harassment? this is a hypothetical, right? So I just used 20 as something that might raise the possibility that this was not proportional and that maybe the parties needed to start with a smaller number of more important critical people. Okay, so more about this reasonably calculated deletion from the current rule. The former Rule 26B1 that those of you that took civil procedure before this year may recall included the sentence, relevant information need not be admissible at the trial if the discovery appears reasonably calculated to lead to the discovery of admissible evidence. That sentence was in the rule when I was in law school 1,000 years ago. So the advisory committee said that parties and courts misunderstood this phrase as being part of the scope of discovery. A comment I did not understand because it was, included in a part of the rules that was titled scope of discovery. But whatever. So they replaced that old sentence with kind of one of the key ideas there, which is information within this scope of discovery need not be admissible in evidence to be discoverable. So, for example, if you are deposing a witness in a deposition, you may ask that witness a question to which their answer is going to be inadmissible hearsay. So if you were actually asking the question at trial, their answer would be inadmissible. That doesn't prevent you from asking that question in a deposition. So just because something is going to be inadmissible in evidence does not mean that it is not discoverable. And that concept is still in the rules. Great. Here's another multiple choice question, which I don't know if it's kind of run off the screen for you there. Let me just read it. Plaintiff sues her former employer for illegally firing her on the basis of age. Defendant defends on the ground that plaintiff's job performance was deficient. Plaintiff serves an interrogatory asking defendant to identify the custodians of emails and text messages that refer to plaintiff's job performance in the last 2 years. Which of the following statements is most correct? A. The interrogatory is improper because it does not seek information that is relevant to any party's claim or defense. B. The interrogatory is improper because some of the information it seeks may be confidential. C. The interrogatory is proper because information about the location of relevant documents and the identity of witnesses with knowledge of relevant information is discoverable. D. The interrogatory is proper because emails and text messages are considered documents and are discoverable. So, the correct answer is C. The interrogatory is proper because the information about the location of relevant documents and the identity of witnesses with knowledge of relevant information is discoverable. And I'm going to get to why that is on the next slide. But you can see here that the plaintiff, a key issue here is, was plaintiff fired because of her age, or was she fired because of her deficient job performance? So her job performance is key to her claim. What she's asking in this interrogatory is for the defendant to identify, which people have emails and text messages that refer to plaintiff's job performance in the last 2 years. So even though all she's doing is asking for custodians of emails, that is still relevant information and very important information that she's seeking in discovery. So let's look at the other answers and make sure that we understand why they're wrong. A, the interrogatory is improper because it does not seek information that is relevant to any party's claim or defense. Well, as I just said, this information is very relevant to her claim because she's asking for basically the location of emails and text messages relating to her job performance. B, the interrogatory is improper because some of the information it seeks may be confidential. That may well be true, but that is not a valid reason for resisting discovery. That doesn't mean that the interrogatory is improper. The correct response to any discovery that requests confidential information is that a protective order should be put into place, a confidentiality order where the information is not subject to the public record and that the parties are under under an order to keep it confidential. And D, the interrogatory is proper because emails and text messages are considered documents and are discoverable. Well, yeah, emails and text messages are considered documents, but that doesn't mean that they're discoverable. They still have to be relevant and proportional. It doesn't just mean because it's an email, it's discoverable. Okay, so this idea of discovering the existence and location of documents and the identity of witnesses with knowledge, the reason that this may seem obvious, or it may not. The reason that I'm making a point of it is that the 2015 amendments actually eliminated part of former Rule 26b1, which gave examples of this kind of discoverable information. So the rule said, quote, the existence, description, nature, custody, condition, and location of any documents or other tangible things, and the identity and location of persons who know of any discoverable matter. These things were listed as examples of discoverable information in the scope of discovery before December 1st, 2015. In explaining this deletion, the advisory committee in its official notes confirm that this matter is still discoverable, even though they deleted it. But they said that this phrase was just eliminated as clutter. It was cluttering the rule. So there you have it. It's still discoverable according to the notes, but it was eliminated as cluttering the rule. So that brings us to the end of 26b1, the scope in general of discovery. Now, there is also the next subsection, which is 26b2, which has some other provisions that put additional limits on the scope of discovery. Where if you apply to a court, the court on its own or on motion can limit discovery for various reasons. And one of them is in 26b2b and deals specifically with electronically stored information, so emails, text messages, Facebook postings, what have you, and deals with ESI that is not reasonably accessible. And where this comes from is there were several cases sort of early on in this whole electronically stored information revolution where information was sought that was not contained in online sources like emails, word processing, things that you could just go to your computer and pull up, basically. So, for example, companies would have backup tapes of, like all the activity of the whole company would be backed up on a tape for various periods of time. And when I say tape, I mean literally like a magnetic tape, not electronic. And so when parties wanted these backup tapes produced, it did raise considerable issues of burden and expense because you can't you have to fast forward through tapes, and you can't really search it, and the way that they were put together wasn't meant for anybody to be searching it, and so it would sometimes take thousands of attorney hours to go through these tapes and find responsive information. So a backup tape in that example would be your prototypical ESI that is not reasonably accessible because of undue burden or cost. And so 26B2B specifically addresses that issue and says that if you are the responding party, you need not provide discovery of ESI from sources that you identify as not reasonably accessible because of undue burden or cost. Then on a motion to compel discovery by the requesting party or for a protective order by you, the party from whom discovery is sought must show that the information is not reasonably accessible. So the burden is on the one that's claiming it's not reasonably accessible. If that showing is made, the court may nonetheless order discovery from such sources if the requesting party shows good cause, considering the limitations of Rule 26B2C, which we're going to get to in a minute, and the court may specify conditions for the discovery. And so what the advisory committee said about this was when the rule says the court may set conditions for discovery, that might include payment by the requesting party of part or all of the reasonable costs of obtaining information from sources that are not reasonably accessible. And a requesting party's willingness to share or bear the access costs may be weighed by the court in determining whether there is good cause for the production. Finally, the last subdivision of 26B2 is subdivision C, which lists even more reasons to limit discovery on motion or sua sponte. If the court determines that, one, the discovery sought is unreasonably cumulative or duplicative, or can be obtained from some other source that is more convenient, less burdensome, or less expensive. Two, the party seeking discovery has had ample opportunity to obtain the information by discovery in the action. Or three, the proposed discovery is outside the scope permitted by Rule 26B1, which simply reincorporates everything that we just talked about at the beginning that's in 26B1, non-privileged, relevant, proportional to the needs of the case. Looking at this first one, the discovery sought is unreasonably cumulative or duplicative, or can be obtained from some other source that is more convenient, less burdensome, or less expensive. Parties try this one a lot, or also when students are first trying out objections to discovery requests, a lot of times they will suggest, to the plaintiff, well, you could get this information from, some government agency more easily than you could get it from us. Well, no, I mean, that's probably not true. It's probably much easier for the defendant to reach into its files and get the information than for the plaintiff to have to go to some government agency. But so courts are somewhat suspicious of this argument that, oh, this is easier for you to get somewhere else. So here's an example. An inmate sued when the prison failed to attend to his serious dental problems, and he requested a copy of his dental records in discovery. The defendants argued that the records were equally accessible to plaintiff as to them. And the court rejected this, saying, plaintiff was only permitted 1 hour every 6 months to review his file. So they really didn't have equivalent access to those records. So that's it. Thanks for hanging with me to the end of the scope of discovery, and I will see you next time. I hope you have a good evening or a good day.